rise.
Very impressive.
Get yourself sorted out.
Yes, so do I. I forgot about that.
Yes.
My lords, what please do. Before I begin, I wish to make a few points of correction. Yesterday, on the question of the rules,
The day before yesterday.
the day before yesterday, my lord.
Yes.
Abbreviated to yesterday.
Yes, my lord. I'm sorry about that. Yes, on the question of the rules, I indicated that the Court of Appeal had made a finding on that. That, in fact, is inaccurate. There were substantial arguments on the question of the absence of rules and the effect on the OUR's determination.
Yes.
In its written judgment, the court did not even advert
Yes.
to that part of the case. It was a case put forward by the appellants who were the respondents in the Court of Appeal. But my submission was correct, and to the extent that no issue was made of the absence of rules before your lordship's board. And therefore, hence my error. It's not a point on which we looked at all in preparing for this matter. And in fact, it's not really something addressed, I don't think, in the case. So that's where it is at this moment, as far as the submission that the absence of rules precluded the Office of Utilities Regulation making any determination or functioning at all.
Everybody at the time appears to have proceeded on the basis that it was axiomatic that the office had power to alter the terms of individuals' contracts.
Yes.
Simply by making a determination. Nobody at the time challenged that.
Yes.
That's why the minister felt he had to step in.
Well, my lord, well, indeed, the parties themselves,
Yes.
after the ruling on the rear one,
Yes.
made it a term of their interconnection agreement that prices for interconnection would be adjusted consequent on further determinations by the Office of Utilities Regulation.
Can you show us where that is?
Oh, definitely, madam.
Volume 2. Or was it assessment on volume 2, page 690?
It is, the agreement commences, my lord, and I'm grateful to my friend,
Yes.
at page 682 of volume 2.
Yes. Is 682 is, as it were, the short agreement that annexes to it the long agreement. It is the long agreement which is the material one, as I understand it, beginning at 690. Is that right?
Well, yes,
That's the long form interconnect agreement.
Yes, my lord, but the
Yes.
two go together.
I was trying to find in this where there's a provision for adjusting price.
Yes, my lord, that is to be found at page 701 and 702,
Yes.
beginning at 23.1, review and amendment.
Yes. But that's an
Without-
inter-parties. That's an inter-parties
That's the
process.
agreement between
It's cable and
Cable and
wireless.
Wireless and Digicel.
Yes.
That their agreement is whenever a further rail is adjusted by the Office of Utilities Regulation, then their charges will be adjusted in accordance with that.
Well, one party may seek an adjustment when that happens. There should then be negotiations to see if the adjustment can be agreed, and if it's not, you're into section 34 of the Act.
Well, my
Isn't
lord.
that right?
Well, 23.5, I submit, makes the adjustment mandatory. If the event giving rise to the review is approval in whole or in part of a revised reference interconnection offer submitted by Cable and Wireless Jamaica, the parties agree that the relevant amendments will include amendments to reflect the principles in the approved rail.
So this is simply a private agreement between these two parties, though, is it?
Yes, my lord, but it is an agreement to conform and abide by determinations on further rails submitted by Cable and Wireless. So, in effect,
Maybe, but it's entirely outside the statute, is it?
it cannot be with respect, my lord, because
This agreement can't give the office statutory power, can it?
no,
It
well,
can give them a power as an arbitrator, perhaps, but
no, but it certainly indicates that the parties recognized the authority of the Office of Utilities Regulation and agreed to abide by its determinations.
It certainly reflects the latter.
Yeah.
It doesn't, it seems to me, necessarily reflect a recognition that the OUR has got the power to change the agreement. But the agreement was on the basis of RIO 3, as I understand it. And
Yes, my lord, but the agreement is to abide
yes,
by any changes made in RIO 4.
having looked at this 23.5, I take your point that the parties were proceeded on the basis that their contract was on the footing of RIO 3 as it then was. If there was a change, then they would need to adjust the terms of their agreement.
So it is a little, I submit, difficult for them, having entered into this agreement, to complain that, look, because you haven't made rules, we are not going to abide by that.
But they're not complaining, are they, about any failure of the arbitrary process? Are they or are they?
Well, in effect, that's what they are saying. In effect, they are saying, look, because you didn't make rules under 29.3, we don't have to abide by your determination on RIO 4.
But there hasn't been a determination,
Yes, my lord.
what, of a dispute arising under clause 23.
But 23 doesn't depend on a dispute, my lord. 23.5
Well, it depends
is
upon
what...
one party seeking to amend the agreement. And so is there one of those? Where's the review notice?
No, no. What 23.5, my lord? Well, that is a matter between the parties. But what we are here about is whether or not the minister had a power under the statute to tell the Office of Utilities Regulation what to do or what not to do.
But this agreement doesn't help to answer that question, does it?
Not at all, my lord. But it helps to answer the question whether or not a party to this agreement could say that the Office of Utilities Regulation had no power to act given the absence of rules. Because that question doesn't arise. They having agreed to conform with our ruling. In other words, they recognize at all times that a RIO would be coming and that they would adjust the agreement in terms of the RIO. So the absence of rules, I submit, is a side wing, having
The real
regard to
point,
the
as I
agreement.
understand it, the real point that you're facing is not that they couldn't act because there were no rules. The real point is that they didn't have to act. And if they didn't have to act, well, then the minister is entitled to direct them not to act. Isn't that the main point you have to address?
And that point, my lord, is I submit, a fairly straightforward point to address.
Yes.
Because the question then is not whether we had to act. The question is, was it 29.3 which gave us the power? Or was it?
You need to find a duty, not a power, don't you?
Well, the duty is to consider the agreement. If having considered the agreement, we reasonably formed the view in the Wednesday sense that the agreement had to be adjusted, then we then had a duty to adjust it. The duty is to consider the agreement. Once it is lodged, our duty is to consider it. Does it achieve the statutory objectives? If we are satisfied it does not, then we have a duty to exercise the power that we have to see that it does, whether that power involves lowering rates or raising rates. But it's a duty to consider the agreement and satisfy ourselves the statutory objects are achieved. And the question, my lord, is this: whether or not the power to make rules is the power that gives us that duty. And I submit it is not. The rules are merely the way by which that duty is exercised, the methodology, the process. The statute gives us the duty to consider and act. The power to make rules is merely a power to achieve the route to the end. And therefore, it is no answer, I submit respectfully, to say, oh, no rules were made, therefore, there was no power, and therefore the minister's direction did not prevent us doing something we could not do. Because what had happened, if we had put in place rules the day after the minister issued his direction, it would then become void. What would have happened if the day after the minister issued his direction, we prescribe rules? And prescription of rules is not a difficult thing. What would have been the position? So I submit the question to ask ourselves is whether or not the minister's direction precluded us performing our duty, not whether or not we had made rules to set out the manner in which the duty would be to exercise. The question is, was there a duty? Was there a function, which is really the statutory word, which the minister's direction prevented us exercising? And the answer, I submit, is a resounding yes, because we had a duty to consider the interconnection agreement, or the reference
Even
interconnection.
assuming you have a duty to consider it, don't you then, I mean, the case, as I understand it against you, is that, of course, assume you have a duty to consider it, you then have a duty to obey the direction which tells you how you act in relation to it.
And that is why, my lord, I say the question of rules is irrelevant. That is the issue.
That's
And
all you're
I
at
wish
at the
to
moment.
turn to
All you're at the moment is simply saying they can't win simply because there were no rules. That's your point.
Yes, and that I submit is not a route to go. The question is, did Section 6 give the minister the power to take away from us a duty, a function, a power?
You say he stopped you doing your job. That's what you're
That's
saying.
what we are saying. He stopped us doing our job. And the question is, does Section 6 give him that power?
And what
And
did
to that I wish to turn.
But what job do you say he stopped you doing? Is this in relation to Section 29.3?
29,
Because that simply gives you a power to object to an agreement which has been made, doesn't it?
yes, my lord. 29.3. And inherent in that is the duty to examine, consider the agreement, and see whether or not it has achieved the statutory objects. 29.4 goes further.
But I don't myself follow at the moment how the direction stops you exercising the power under Section 29.3.
Yeah. Well, I would say the duty to consider. Because, my lords,
Well, let's suppose you have a duty to consider.
yes,
how does the direction stop you exercising the power that you have in the exercise of your duty to consider the document?
Very right. Because what the direction has said is under no circumstances should you interfere in the price retail or for interconnection in the mobile cellular market. So therefore, once there's an interconnection agreement in relation to the mobile cellular market, it would be pointless for the regulator to consider it as far as prices go. Why bother to consider it if you have no power, no authority to intervene with the price? And what the minister is saying is, under no circumstances do you interfere with it. And if we are told not to interfere with it, why bother to even read it? The problem with the minister's direction, my lord, it commands the same result regardless of the circumstances. There's therefore no discretion left.
I'm sorry, it's my fault entirely, I've just got lost.
I'm sorry.
This is, the agreement we're looking at, which we're talking about, is the agreement which begins in 682, is that right? Is that right?
It begins at 682. There are two agreements, my lord, but they are intricately resolved and they bear the same date.
The one that matters is the one that begins at 690, which is the longer.
In order to affect the terms of that agreement, what do you have to do?
Insofar as prices for interconnection go, my lord, the Officer Utilities Regulation, OUR would need to read it, would need to see whether the terms are consistent with fair competition, efficiency in industry. The phrase uses the word duty, see that the prices are not out of the reach of customers, and all the objects set out in 3 and 4.
How do you give effect to that?
We make a determination, say, look, we have read the agreement, these prices are too high, these prices are too low, these prices are uncompetitive, or as the case may be.
Which power do you use which then changes the rate? In the agreement?
There are several powers. 29.3 says we can object. 29.4 says, uses a different phrase. It doesn't say by notice, but 29.4 says...
Make a determination.
Use the word. Thank you, my lord. Let me just get the act right here.
And so, what we were looking a few minutes ago at various clauses about 23.1 to 23.5 and so on. What relevance, if any, do they have to this now?
To demonstrate, my lord, that the direction absolutely precludes us acting if an agreement is in place or if somebody is declared dominant under 33. Because to answer your lordship's question, there are several paragraphs that give us the power. There's 31, where there's a disagreement. There's 33, where there's a dominant provider. All of these provisions say that we are entitled to see that prices are cost reflective and achieve the result. What the minister's direction does is, regardless of the context or the situation, if there's a dominant party...
Mr. Batts, can I see if I can perhaps help you with this? The agreement between Digicel and Cable and Wireless made provision for terms, the actual charges. And the agreement was based on the then existing RIO. And the parties agreed that if the terms of the RIO were altered,
any future RIO.
The agreement would have to be altered to reflect that.
That is so.
And the power, it seems to me, that the office had was to agree or approve a revised RIO. And if they did that and exercised that power of agreeing a revised RIO put forward by Cable and Wireless, that would then inevitably have the knock-on effect that the parties were contractually bound to adjust their terms. Isn't that the position?
Yes, my lord, insofar as the agreement between Digicel and Cable and Wireless.
That was the way that the office could affect the terms upon which Digicel provided their services.
Yes,
and that's what they objected to.
That was one way, my lord.
Yes.
That was one.
And the minister stepped in to stop this process, and he called it capping. But there's an issue as to whether it really is properly to be described as capping.
Yes.
But that's what he said you're not allowed to do.
Well, no, my lord, and this is the point. The minister's direction makes no reference to the agreement between Cable and Wireless and Digicel.
Yeah.
The minister's direction is intended to apply generally. It is saying that under no circumstance are we to exercise our duty to consider prices in the mobile cellular market for interconnection or retail.
That's what he said, but the reason he said it, as I understand it, was to stop this process.
No, my lord. His reason advance is very interesting. His reason is that there was an interested fourth provider, which we now know was AT&T, who had communicated to him that they didn't want to participate in a regulated market, and they wanted to know that when they came in, they would be free to set prices as they wished. So he was telling the regulator, back off on mobile-to-mobile prices. Do not consider any changes as far as prices are concerned, because we want to induce this fourth set. It had nothing to do, as far as the minister's affidavit and the words of on the issue between Cable and Wireless and Digicel. I raised this agreement only to indicate that the complaint about the absence of rules is with respect disingenuous, because Cable and Wireless and Digicel had in writing agreed to this procedure. So the rules were to that extent irrelevant, because they had agreed between themselves to the continuing adjustment of the rail and to change the terms of their contract in accordance with that process. But otherwise than that, the agreement I submit is irrelevant to the question whether or not the minister's direction was intra vires Section 6. The question for this court I submit is whether Section 6 enabled the minister to do what he did, which is take away from the OUR the duty, stroke the power, stroke the function of adjusting prices in mobile to mobile where the OUR considered it was necessary in order to achieve the objects of the Act. It had nothing to do with the particular dispute, insofar as the record goes. I can't speak as to what other motives were in the minister's head, but insofar as what he has put on affidavit, it had to do, according to him, with a fourth provider who he was concerned to induce to the Jamaican market. And he put that imperative above the question of fair competition between those already in the market, the interests of the customers who would have had to pay the bills, which the OUR had, I submit, a mandatory duty to also consider.
Well, he says he weighed up all these factors together, including the interest of the, quotes, fourth provider.
Interestingly, my lord, he says that in an affidavit, when he was seeking leave to come before your lordships, the evidence before the court, well, let me put it the other way. He says that subsequent to the matter being brought before the court, because he puts that in an affidavit, the contemporaneous documents, his letters, and the very recital to the direction advert to one thing, and that is the advantage of getting investment from overseas. And as far as his conversations with the Director General of the OUR goes, he spoke to the Director General about this fourth provider. The other things he only mentions after the fact when we are before a court.
Well, you're not asking us to decide whether that was a sensible policy to sacrifice everything in the interest of getting somebody else in to make the investment in the market, are you? I mean, that's, you know, governments make these decisions. And
no, my lord, but I'm asking the court to decide whether the minister was entitled to ignore the other statutory imperatives, one, and secondly, whether Section 6 gave him the power to remove the responsibility from the Office of
Well, I
Utilities
understand the
Regulation where the statute placed it.
I understand number 2 entirely, but 1, I mean, what, you know, why are we going to assume that he ignored everything else? I mean,
Well, my lord, the recitals to the direction demonstrate that. He had 4 comprehensively phrased recitals, none of which even advert to any of the other statutory imperatives. But that's not the primary focus, I concede. The primary focus is whether or not this was a responsibility which the statute placed on the Office of Utilities Regulation, and whether Section 6 empowered the minister to take away that responsibility. And that is the submission I would wish to turn to, my lord.
I mean, speaking for myself, that's the issue.
That is the issue, my lord. Thank you.
That's as it was, certainly as it was seen at the time. That's why you've got legal advice and so on. Can we make this determination or not?
Yes.
Because on the premise that making the determination was actually going to flout the minister's direction.
That is so, my lord.
Yeah.
That is so.
Yeah.
I began, my lord, by indicating I had a few corrections. And the first I've already made, which is that the Court of Appeal did not, in fact, rule on the question of rules. The second have to do with some printing errors in our printed case, my lord. That is the case for the first respondent. I'm afraid I don't know which bundle it is before your lordship, but I hope your lordship have it very close to hand since I'm on my sheet.
This is your 80-page printed case, is it?
It's not quite as long as a certain speech yesterday, my lord. I apologize. I should say not quite as short as a certain speech yesterday. The first error, my lord, appears at paragraph 6. My lord's with me? Yes. Paragraph 6, in the references to the left, in the column to the left, you see a reference to Jeffrey Rolfs about the middle of the paragraph. Consultants such as Jeffrey Rolfs.
While we're on this document, has anybody got a spare copy? Because mine was bound in such a way that it didn't actually bind in the pages, and I got a lot of loose pages. It'd be more convenient if I had one that was.
We will endeavor to obtain one, my lord. I don't have one close to hand. Do you have one? The reference there to the left, my lord.
Would it, my lord suggests that it might be more convenient if we were given these corrections in written form, in the form of a revised bundle, rather than spending time on this.
I will do that, my
Yes.
The other correction, my lord, is to something my learned friend said yesterday when he pointed, my lord, your lordships, to volume 2, page 955 of the record, and stated that that document was the very first reference interconnection offer. Volume 2, page 955. And I understand my friend's error because I was also misled by it. But my instructions are that that document at page 955 was in fact an attachment to an application for the license. It was not the first reference interconnection offer. The first RIO, my lord, is unfortunately omitted from the record. We searched very hard for it. It ought to have been at volume 1, page 424.
Is there a chronology anywhere of all this?
Well, I attempt to set out one at the start of my case.
Somebody once told me that the chronology is the most important document in any case.
No, we didn't put together a jointly prepared chronology, but my case...
I'm in a bit of a muddle about how all this fits together, and how these various agreements, how the RAIOs came into operation, how they related to the agreement,
Indeed.
whether there was a dispute under the agreement, whether there was any ever request to arbitrate.
Yes.
All those questions are very, very obscure to me. Just
Yes, madam.
a two-page chronology, who knows, we might be well off.
Thankfully, my lord, on my submission, we need not consider ourselves with all of that. When
That's
the
the kind of submission we like to hear.
the question of rationality is no longer before us. That's issue 4. That would have invited that discussion. All we are here about is the construction of Section 6, my lord. So I don't think we need trouble your lordship with all of that. But if necessary, my friend and I, I'm sure, could do something after we adjourn. But I have, in the start of our case, attempted as best I can to put forward a chronology, my lord. So that the RIO, the first RIO, there's a cover letter which refers to it at volume 1, page 424. But the document itself was unfortunately omitted, my lord.
What was the date?
Volume 1, 424. Yes. The date of that letter, my lord, is the 15th of May, 2000. And it's a letter from the OUR to Digicel attaching the first RIO that Cable and Wireless had filed. But the attachment is unfortunately omitted from the record. So, my lord, I know.
So all that predated the April of 2001.
Oh, yes, my lord, because that first RIO was ruled on by the office, which said, having consulted the parties, that for convenience, let us insert a term in the RIO that the agreement in future would be adjusted as the further RIOs are assessed. And the parties agreed. And that is the process by which they all merrily proceeded, my lord. As the RIO is adjusted, the agreement will be adjusted. And they proceeded merrily until the OUR decided to reduce prices.
Which was the number of the RIO which gave rise to the April agreement?
There is RIO 3, my lord, and then the RIO 4, they chose for the first time to reduce the cap, and then you had a problem. While the cap was being increased, there was no problem. Because I'll come to show, my lord, that in fact they had been regulating prices from almost day one. But it was when they chose to reduce it that we had a problem. No, my lords, we know, I submit, that Section 6 preserves the decision-making role and hence the control. And my lords, you will recall that on Tuesday, I used the point of departure, the distinction drawn by my friend between control and influence. And I submitted that, and I agreed with my friend, that there is a dual regime in this statute. One regime, the minister controls, the OUR influences, and that has to do with the spectrum, the licensing. The other regime, the OUR controls, but the minister influences. Where it is the minister who controls, the statute is explicit and clear. It says the minister shall direct. And an example is Section 10. All other sections, we have to look to Section 6. And I submit Section 6 preserves the control of the OUR and only allows the minister to influence. And I submit that we know that Section 6 preserves the control of the OUR because Section 6 says that the direction is to be of a general nature as to policy to be followed by the office in, and these are the exact words of Section 6, the performance of its functions.
Is it your submission that if the word directions had been guidance, that would have been exactly the same?
Indeed, my lord, had the word guidance been there, the word general would not be necessary. Nor indeed, had the word guidance been there, would the words performance of its functions be necessary. The legislature could simply have said, the OUR shall act in accordance with the guidance given by the minister. not having used the word guidance, the legislature had to use the words general directions in the performance of its functions under this act. And let us not focus, my lord, on the word guidance.
Where do
Because
is the word anywhere in this act?
it is, my lord,
Where is it?
section 33.
Section?
33, a derivative. The word guided appears at section 33.
Oh, yes.
Guided. And this is the point I want to make. Context is very important. Because although the word guided is used there, it is clearly prescriptive. What the legislature is there saying, where the office is required to determine prices for a dominant provider, it shall be guided by the following principles. Costs shall be borne by the carrier whose activities cause those costs to be incurred. These are clearly prescriptive, mandatory considerations. The statute is detailing how the costs of the dominant provider are to be determined. So there's no magic in a word. It's the context in which the word is used.
Well, just picking up on that,
Yes, sir.
Section 10, you accept is effective to require obedience from the OUR from a direction by the minister.
That is so, my lord.
And the words there are, by direction, require the office to invite applications.
That's right, my
Now,
lord.
if you contrast that with Section 6, a direction as to the policy to be followed, why do you say that that does not require obedience by the OUR?
Indeed, my lord. First of all, my lord, the legislature chose to use the phrase general direction. He didn't use general in section 10.
But-
Secondly, my lord, secondly,
Yes.
in section 6, the legislature made it clear that it was to be in the performance of the OUR's function, so that it was still the OUR who was to carry out its duty, exercise its powers. Functions under the Act means duties and powers by definition. So section 6 makes it clear that it was the OUR who was to be performing its functions, not the minister. Therefore,
But under Section 6 plainly includes a directive to the office to do whatever it is directed to do, so long as the direction is of a general nature, doesn't it? Because that's made clear by the last 7 or 8 words.
but it was still for the OUR to perform the function.
Well, I'm
If-
sorry to
Subject to
interrupt you
direction.
about that, but surely under Section 10, the OUR is performing a function.
With respect, no, my lord, under section 10, the OUR is performing the minister's function.
Well, it's
Section 10,
it's requiring the office to invite applications. I mean, do you
at
suggest...
on the direction of the minister.
Well, that may be, but do you suggest that in compliance with the direction under Section 10, the office isn't performing a function?
It is performing a function which is under the control of the minister. The minister is responsible for the issuing of licenses, for the cancellation of licenses, even, I dare say, for the pricing of licenses. Licensing under the Act is the minister's portfolio. The OUR is merely his instrument to carry it out. And that is why Section 10 says, at the direction of the minister, the office shall do X, Y, Z. The result, the conduct, is really the minister's. The OUR is really just his foot servant for the purposes of Part 3, the licensing and the spectrum.
Well, if
It
the,
is totally different when
if
it
the
comes...
language in Section 6 was that the minister shall give to the office such directions of a general nature as to policy, would the direction in the present case be valid?
With respect, I submit no, my lord. It still would not be. Even if the minister had an obligation to give a general direction as to how the OUR was to perform its function, it would still be for the OUR to consider the agreement and to determine whether or not it achieved the statutory objectives.
What's the point then of giving the minister a power to give directions?
Because
they
my
can be
lord,
ignored.
I see, my lord. That is just the point. The point is, my lord, to allow the minister influence. Remember the dichotomy, to use neutral words, control and influence. Some parts of the statute, the minister controls, but the OUR will influence. So when it comes to licensing and the spectrum, the statute says the OUR may give recommendations, may give advice, but it's the minister who decides who gets the license. That's part 3. The other parts of the act, the statute dealing with interconnection, ensuring that competition is fair, that the consumer is protected, the statute clearly places the responsibility, the control on the OUR. But the minister, by Section 6, is allowed to influence the OUR's decisions. And how does he influence it? Well, what he attempted to do in this case. And I will give my lord the example. If the minister wished to ensure that market forces were given greater prominence, then his direction, I submit, should have read as follows. The OUR is to adopt a more market-oriented approach as opposed to a more interventionist approach when considering prices and interconnection. The OUR is to adopt a more market-oriented approach as opposed to a more interventionist approach when considering prices and interconnection charges. Interestingly, my lord, this example I pull from the appellant's written case. They put that there as an in other words. They were saying, yes, this is what the direction actually said. This is another way of saying it. I submit, my lord, that that is not so. What the minister did, and his error, is to have said, under no circumstances must you adjust prices on interconnection.
So, supposing got one of those directions you've just read out, what then?
Well, the office now, when considering a matter, would give weight to the direction, would give it effect by giving weight to market considerations.
How much weight? Whose decision as to how much weight?
It has to be the offices, because the statute says it is the office who must determine whether or not interconnection agreements achieve the statutory objects. So, all other things being equal, the office would be expected to take a hands-off approach on prices. But there may be factors which weigh the other way. If the prices were now leading to anti-competitive practices, or were likely to, as in this case. If the prices would have meant that some consumers would be asked to bear a burden totally unrelated to costs.
There are two aspects.
Case, then the office would be able to, I'm sorry, my lord, weigh those factors in the balance and say, well, notwithstanding the fact that we have to give a more market-oriented approach, the circumstances necessitate intervention. And my lord, this is not a difficulty.
Well, could I just interrupt you for a moment? Don't want to interrupt your flow, but it seems to me it's important to note that there are two aspects to the obligation under Section 6. First of all, the directions are to be followed by the office.
Yes.
And indeed, lest there be any doubt about that, the office is enjoined to give effect to the directions.
Yes, my lord.
So to repeat my Lord Roger's question,
Yeah.
if you're given an instruction to adopt a more market-oriented approach,
Yes.
how does the office set about giving effect to that direction?
Yes. By any contemplation that they have, they come with a mindset that, look, the market is what is important, the free market. Circumstances must have to be very serious for us not to give the market prominence.
So
and they come with that mindset.
Well, if the circumstances are sufficiently serious,
Yes.
do you suggest they can ignore the directions given?
They wouldn't have ignored it. It's just that the circumstance would have to be
I'm sorry, that
of
was-
that degree
that was the
to
wrong-
cause them not to follow it.
Yeah, that was the wrong word.
Not to give the market full rein.
Well, they don't have to comply with it.
They don't have to hands off entirely on prices.
Yes.
They don't have to. Because the minister, any other decision, my lord, would mean that it would be the minister exercising the discretion. Because the directive would have compelled a particular result. Under no circumstances adjust prices. The Parliament may well have said the minister may direct the office as to its decision in any particular matter. That would have been it. And it's not an unusual situation. This is a situation faced in the Laker case, in the Rickson case. In both those situations, although the word guidance is used, the law stated that the regulator should comply with the guidance. And Lord Sedley J. in Rickson did give a gloss on that, my lord. At page, this is to be found in volume 4, page 43 of the authorities. Tab 43 of the authorities.
Well, we looked at this. This is page 6, isn't it?
My friend referred to page 6, my lord, which establishes that the word general emphasizes the non-prescriptive nature of the guidance.
We mustn't overlook the third fresh paragraph, must we?
The one beginning, what is the meaning?
Yeah.
Yes, my lord. Clearly, guidance is less than direction, and the word general emphasizes the non-prescriptive nature of what is envisaged. Here we have general direction as to the performance of its functions. Performance of its functions. Those words in section 6 are critical for an understanding of the context.
Well, I wonder if they really are. I mean, Mr. Betts, you know, here is the policy to be followed. Well, I mean, what else could it be than by the office in the performance of its functions? That's everything it does, powers and duties. And it's only, of course, under this Act, and that has to be spelled out too, because this doesn't extend to the office's functions under some other Act.
Yes.
And so all it's really saying is this is what the office has got to do under the Act. You've got to give effect to the...
And, my lord, what is it? The office must consider the agreement or the rear or the dispute. Can it be said that the office is considering the agreement, the rear and the dispute, when all it is doing is following the dictates of a minister who isn't even present to consider the argument or the agreement or the dispute? It would be a fallacy. We would be the instrument of a dictator who has not heard or seen or read the document before us. Because what his direction does, my lord, let us look at the direction, is compel a particular result regardless of the circumstance. And Lord Sedley dealt with that dilemma here. Yeah, because the question was asked clearly, I suppose, in the course of argument, then if the guidance has to be followed, how do we know they have followed it?
How do we know what?
How do we know they have followed it? In other words, in Sedley, the judge Sedley, in Rickson, or Reichson, I don't know, the question emerged. Well, if they are not, if what the argument was that the general guidance should be followed, and they should have done what the minister said. And the court said, no, the general guidance was to be considered, but the decision was still for the authority. And the question was, then how would we know if they ever followed it? And the judge at page 8 made it clear, in the middle of the page, the paragraph beginning, fourth down, a failure to comply with the statutory policy guidance is unlawful and can be corrected by means of judicial review.
Your point is this, is it, that if one had a direction of the kind you indicated earlier, namely if market force, to give market forces greater prominence, that would be okay, because it would be a general direction.
That's so.
And it would leave some discretion to the...
Precisely, albeit a discretion influenced by the policy.
Whereas what's not would be a direction which says, shall apply market rates.
No, my lord. A direction which says, under no circumstances should you adjust prices. Because that's what the minister said. Regardless of the circumstances, under no circumstances are you to adjust prices. So he went right down to the particular result. Not market forces. The direction said prices. In fact, it says retail, interconnection, prices, price caps, charges, tariffs. He compelled the same result in every case, regardless of the circumstance.
I suppose another way of expressing that argument would be, if you think of policy to be followed in the performance of duties, is how you set about performing the duties. Whereas your argument is that he wasn't giving directions as to how you set about performing the duties, he was telling them, don't perform this duty.
I couldn't have said it better myself.
It may not be right, of course.
And if I may, my lord, continue with Lord Sedley at page 13 of this judgment. Very useful judgment. The paragraph at the very bottom of the page, beginning the care plan. The care plan, as Mr. McCarthy readily admits, does not comply either with the policy guidance or the practice guidance issued by the central government. There has been a failure to comply with the guidance contained in paragraph 3.24 of the policy document to the effect that following assessment of need, the objectives of social services intervention, as well as the services to be provided or arranged, should be agreed in the form of a care plan.
13.
I'm sorry, my lord.
No, it's my fault.
It's at,
Yeah, I got it.
yeah.
Thank you.
Yes, sir. So, if I may continue. For the reasons which I have given, if this statutory guidance is to be departed from, it must be with good reason, articulated in the course of some identifiable decision-making process, even if not in the care plan itself. In the absence of any such considered decision, the deviation from the statutory guidance is, in my judgment, a breach of the law, and so a fortiori is a reduction of the flexi team service from 3 hours as originally agreed, whatever the activity, to 3 hours swimming or 1.5 hours at home. So, to answer my Lord Rogers' point, a general direction in the form that I suggested is subject to judicial review. And were the office to ignore it and to impose prices without an identifiable decision-making process providing reasons for departure, certainly the court could have it quashed and the minister could complain.
I can't remember exactly the terms of the
I can refresh my lord. It's contained in my learned friend's case.
yes.
The OUR is to adopt a more market-oriented approach. You can find the case in case.
Right, well that's,
As opposed to a more interventionist
that's
approach.
enough, that's enough. Because,
Yeah.
I mean, would you be departing from it in that situation? If you considered the matter,
That's right.
I mean, would you be departing from the policy at all, or would you simply have it, if it's general guidance of that sort, you would take it into account
That's right.
and then reach your decision?
And weight in the balance so that non-intervention would be up here.
Yes. So you
We'd
would be
start our deliberation with that. And it was for the party, assuming it was an argument between two parties, two interconnectors. They would have to come now with reasons why we should be. And that would be the approach I submit, my lord.
So if the minister had said priority should be given to attracting additional competitors into the market
Yes.
over the maintenance of low prices.
Yes.
That would have been perfectly all right. It would have left it open to you to say, well, we don't actually
Yes.
need to have a complete abnegation of price capping.
That's right.
We've just got to make quite sure that if we price cap, we're not going to discourage
That's right, my lord.
more competitors from coming into the market.
That's right, my lord. So long as a particular result is not compared, and this is established also in the Laker case and the Lancashire County Council case.
So if they had the second paragraph of the direction, but not the first paragraph, it would be all right.
Yes, my lord, we made no complaint about the second paragraph, which in fact reflects what is in the statute anyway, the second paragraph.
Could you just show us the price provision in the OUR agreement?
In the OUR agreement, my lord? The determination. Yes, my lord. That is what in the Rio 4, my lord.
Or Rio 3, because it's the Rio 4 is going to amend Rio 3, isn't it?
I see. Yes, the Rio 3, my lord. If you look, my lord, at volume 3, tab 17, I think it should be there. Is that the right one? Huh? Oh, I'm sorry, that is the wrong reference, my lord.
Well, we were looking at the agreement before,
It's
which is in tab 2, page
volume
690.
tab. Oh, that's the real, my lord, is volume 3, tab. That found it yesterday.
I just wanted to see what the status quo was in the agreement.
Yes,
And
that's
the status
my lord.
quo is surely that in the April the 18th, 2001 agreement.
Where did it come from?
Page 690 of tab 2.
Funded.
Sorry, tab 2. I don't know whether we have...
My lord, it is to be found, I'm sorry, my lord, at volume 1, page 265.
I'm so sorry, page...
At 265 of volume 1. That is the pagination at the bottom left of the page.
It's the agreement I want to define. Because the agreement is post the determination, isn't it?
No, the agreement, my lord, is post the first determination. But
We're looking at the February the 22nd.
we are looking at
determination.
February
So
2001.
that must be reflected in the agreement, the April agreement.
No,
What
the
I was
agreement.
trying to find
No, the
is
agreement.
the relevant provision in the April agreement
That ties prices.
ties prices to
Yes.
see what the provision is which the OUR, you would say, has power to amend.
Very well.
The agreement is, as we looked at before, bundle to page 690.
We have just looked at the agreement, my lord. This is
It has the price provisions.
There's an annex.
it is at, the agreement is at page 682, but the relevant provision is at 701 of volume 2.
701.
So 701 volume 2, paragraph 23.1 and 23.5.
Mr. Batts, under the agreement, before the new determination,
Yes, sir.
the prices that Digicel could charge were capped.
Yes.
If the minister says no capping, that surely means not only are you not allowed to amend the capping provisions, you've got to remove them altogether.
Yes, that's it. That's it. And that's exactly it, my lord.
And so it's the tariff schedule we're looking for, the one referred to in clause 9.1. Is that right?
My lords,
9.1
perhaps
provides for the payment, the obligation to pay.
perhaps I can assist with that. The tariff schedule is in volume 4 at tab 35. And I understand, my lords, that you were asking as to what was the status quo prior to the minister's direction. And I believe it would have been as stated in the determination. The office had made an interim determination on November 22, 2001.
I'm looking at the one before that.
The April, I see.
The February
The
determination.
schedule refers to in clause 9.1, the April 2001 agreement.
My lord, if you look at page 24, you will see where the last determination was made just before the agreement. And the rates, in fact, were picked up from that and moved into the agreement.
My lord, the determination begins at 265, as I had earlier indicated, volume 1. That is the February 2001 determination, in consequence of which the agreement of April came into effect. Am I right? Yeah. Yeah, I'm going to take him to that page, but I wanted to see the start of it. Thank you. Yeah. My lordship, with me, page 265, volume 1, is the determination by the OUR on that. That was actually, I think, the second rail. But you see abstract on the page following. The Office of Utilities Regulation is mandated to regulate interconnection. The OUR may assess reference interconnection offers to ensure that they are in keeping with the principles and the stipulations outlined in the Act. In this determination notice, the office sets out its final decision with regard to the existing public voice carriers reference interconnection offer. Cable and Wireless is required to submit a revised reel to the office by March 7, 2001. It is anticipated that this reel will be consistent with the contents of this notice. So it's consequence on this ruling that the agreement
265.2
at volume 2, page 701 was signed. Now the relevant pages.
What happened, as I understand, was that as a result of this notice here, by the date of March 7th, a new Rio,
A new agreement was signed.
a new Rio as well.
Afterwards, yes, sir. Afterwards, another Rio came along, Rio 3 and Rio 4.
When did Rio, I apologize because we've been through this.
Yes.
When was Rio 3? It was was it a few days after the...
I'll tell you, when was Rio 3? Yes, Rio 3 would have been sometime in 2001. You see, they had the Act mandated a 3-stage process to full liberalization.
So when it said you submitted a revised Rio to the office by the 7th of March, what number did that revised Rio have? 3, I thought.
Yes, my lord. So that if we look, my lord, at this Rio, at page 271, you'll see the office sets out duration and modification of Rios.
All I'm looking for myself is the document described in clause 9.1 of the agreement as the tariff schedule. Is it in the bundles we have?
Volume 4, tab 35.
Thank you.
Yeah. But that, my lord,
It may have nothing to do with it, but I quite see that. But
the point, though, my lord, is that there were schedule of charges stipulated in this Rio.
17th of April 2001. Top of the page. Top right-hand corner.
Sorry, 4,
yeah,
1702.
1702. Thanks. Yeah, thanks.
The point, however, my lord, the tariff schedule really just reflects the result of the ruling by the office. That follows on the ruling of the office. The ruling of the office, my lord, pursuant to which the parties contracted, is to be found in this determination of February 2001. And we will see that even at this early stage, prices were regulated for interconnection. You see, at 2.2, under the heading Duration and Modification of Arrears, the office says, given the statutory time frame, the office believes there is a strong case for setting initial charges for a relatively short period. The quality and robustness of the cost information on which some of the charges are based will improve over time as costing systems are refined and made more reliable. Since costs change over time, charges will need to be subject to periodic review, as Cable and Wireless recognized in its paper to the OUR. Furthermore, the system of accounts from which Cable and Wireless has derived its proposed charges is quite new, and typically the development and refinement of accounting systems or other costing models is a process and not a one-off exercise. And then, if you turn, my lords, to page 284, we will see the rates fixed by the office, which the parties gave effect to, recognizing that there will be further arrears and further adjustments. Fixed to mobile rates, mobile termination domestic, and overleaf at page 286, fixed termination, and so on. So that by the end of the document, at page 299, paragraph 13, the office says, the Act requires the prescription of conditions and process relating to interconnection. Such prescriptions relate to the content of arrears, the process of arbitrating pre-contract disputes, and the handling of objection to interconnection agreements. Annex B sets out the proposed rules relating to these matters that the office intends to adopt, and comments are invited. So there was no doubt, my lord, that in the office and all parties contemplated revised arrears and adjustment in consequence. And everything went along very fine so long as the office did not decide that, look, fixed mobile rates had to be adjusted downwards. And it was when that occurred that the minister started to come in and say, under no circumstances whatever are rates to be adjusted.
Apart from Digicel and Cable and Wireless, who else was actually in the market at this time?
There was a company known as Centennial Digital.
One other.
One other, my lord.
And they would have had similar arrangements, so they would have been tied in.
They would have been tied
Yes.
to this, my lord. There may have... Centennial? Yes, I just told. I confirm from my technical people present, there were no other
No.
at that time.
AT&T were sniffing.
Yes, my lord. In fact, AT&T eventually got a license, but they, for reasons best known to themselves, sold it and whatever.
Yes.
Oh, I have sort of forgotten where I was, my lord, so I pardon you to allow me a few minutes. Pardon? Yes, I'd finished with Rick's, my lord.
Yeah. But we're going back to the point I was making before.
Yes, my lord.
You could call this tying the price to the Rio as a price cap. But that was one in existence. If the minister says no more capping, it would leave the status quo frozen. It wouldn't require destruction of the status quo, because that would then destroy the whole basis of the contract. You wouldn't have any pricing mechanism.
That's one way of looking at it,
Yes.
my lord. But on the broader question, if Centennial fell into a dispute
Yes.
with Cable and Wireless, unrelated to that, and they sought to argue in that dispute that, look, these prices for mobile interconnection are too high. The OUR could pretend, if they were to abide by the minister's direction, they could pretend to listen to the argument and pretend to pay attention to Centennial's concerns. But the result of their determination would have been predetermined by the minister's direction. They would have had to say at the end of the day, regardless of how strong Centennial arguments were, that we will not interfere with the prices as they are. So the result would have been predetermined by a direction, even though the OUR had the authority to consider the dispute. But it would have been a more form and no substance.
Yes.
So, if I may just summarize the submission to this point, my Lord, it is that a direction which compels the exercise of the OUR's discretion in a particular way in all circumstances defeats the discretion and therefore the function. In other words, the OUR would no longer be performing its function as required by Section 6. Rather, the minister would be the one exercising the discretion. It is for this reason we submit that the generality of the direction is not only to be assessed by the subject matter of the direction, whether he says it applies to all mobile carriers. That's not the only test. Rather, one must also look at the effect of the direction. If the direction compels a particular result in all circumstances, then it is no longer a general direction. Any other submission, any other position or interpretation placed on Section 6 will compromise the independence of the regulator.
I mean, do you say the effect of the direction is to nullify the arbitration provisions in the agreement, for example, as set out in the statute?
Not only in the agreement, in the statute itself, because the statute provides wherever there is a dispute, the OUR can arbitrate and determine the result. Pre-contract dispute, post-contract dispute, 29(4) deals with post-contract dispute.
Sorry, the arbitration power is, we looked at it before, is that in 30?
There's one in 29(4), talks about resolving a dispute.
That's pre-contract.
29(4), my Lord. The office may, either on its own initiative in assessing the interconnection agreement or in resolving a dispute between operators, make a determination of the terms and conditions of call termination, including charges, resolving a dispute. And 34,
says that the office may decline to act as an arbitrator.
Yes, my Lord.
So where does it have its opportunity to act as an arbitrator?
Well, 34 deals with the resolution of pre-contract disputes, where during negotiation for the provision of interconnection, there's any dispute between the interconnection providers.
May refer for resolution.
Right? So either of them may refer the dispute to the office for resolution. So it doesn't really use the word arbitration, but I submit. We see that, well, it goes on, the official make rules applicable to the arbitration of pre-contract dispute. So it's clearly an arbitral role. And as I say, 29(4) deals with the situation after there's an agreement.
What happens if the office, in the ordinary way, absent any direction, are asked to, but decline to act as an arbitrator in the dispute? Who resolves the dispute?
Well, my Lord, this, I submit, 34(4) is a concession to the free market principle. If the office is of the view that these two players in the market, for example, are not that important, let us say they are too minor. Right now there are several small companies which don't really have very large networks, but they do manage to provide attractively priced phone cards and access to computers, some of which I am yet to understand. But let us say some of these small players had a dispute about interconnection. The office may consider that it's not worth its while to engage and take up time to resolve. You either resolve it yourself or you get out of the market. I can imagine that scenario. But I do not imagine that the office would likely decline to perform. But the statute is just giving this concession to the reign of free market. They have a problem. Remember, this is a dispute about the terms of a contract, you know. And ordinarily, at common law, the state doesn't involve itself in the negotiation and the terms of people's private contract. So all Section 34 is doing is saying where there's a pre-contract dispute, the parties haven't entered into an agreement yet, but they can't agree on a term. They can approach the office and say, tell us, what should the term be? And I suppose the office could say, look, at common law, you would have to resolve it yourself, go resolve it. But I wouldn't...
When Rio 3 was in operation, it was contemplated that there would be future Rios.
And it says so, my lord.
The contract contemplates that.
The contract contemplates that. And
it contemplates, does it, that the Rio 3 will be replaced by Rio 4 and so on.
That's so, my lord. Expressly and in writing. That is what it says.
And the clauses we were looking at before, clause 23.5 and 23.6, provide, in effect, that the parties will, they agree that the relevant amendments arising out of the new Rio will include amendments to reflect the principles in the new Rio. And then clause 23.6 provides for arbitration under section 34 if they don't agree. It no doubt being on the basis, presumably, that these would be, quotes, negotiations for the provision of interconnection within the meaning of section 34.1.
And in fact, my lord, to follow your lordship, 23.6 expressly refers to section 34.
Yes. Yeah. And so, my question therefore is, given that that was the position when this direction was given, what effect did the direction give on either side's case, or have, on either side's case, on the agreement in 23.5, 23.6, or the arbitration under it?
Well, it would mean, my lord, that the result of the arbitration was predetermined.
It is?
The office would sit down, listen to the argument, and then say, we will not interfere with prices because we cannot. The minister has told us not to. So what would be the point of an arbitration?
Well, to resolve the differences between the parties, presumably.
But why bother to hear what they had to say about the difference if you had to decline to act?
But you wouldn't. They'd simply have to apply the relevant criteria, work out what the market rate, a fair market rate was.
With respect, my lord, if they were to comply with the minister's direction, which was do not in any way interfere with prices,
No,
then they would have to say, we will do nothing.
But it's not to interfere, not to cap the prices.
No, my lord, not cap.
Yeah.
It is not to interfere. Let us look at the direction right now, my lord. It is to be found at page 824 of the same record. Page volume 2, page 824.
It wouldn't be an intervention in the mobile market by setting rates. It will be determining a dispute between the parties pursuant to an arbitration agreement, which is something completely different.
Well, my lord, I would submit that the OUR is directed not to intervene in the market.
But you couldn't construe that, you have to construe that direction in its context. Yeah. And part of the context is the agreement of the last Rio, the agreement of April 2001. Since there was a binding arbitration agreement for the setting of rates or resolving a dispute, for my part at the moment, I don't see that there's anything in that direction which would impact upon the operation of the OUR pay arbitrator.
Well, let us look.
Couldn't, I suppose, to say there is an absolute maximum. Well,
my lord, let us look at it in the broad and in. My lord, let us look at it in the broad and in the narrow context. The broad context is this: Cable and Wireless and Digicel were not the only players in the market. So, if we are going to test the validity of this direction, we do not test it by looking at the agreement to see the effect on the agreement. We test it by looking at the market, the role of the OUR in the market, and the effect on the role of the OUR in the market. The example I gave earlier, if Centennial had a pre-contract dispute and wanted arbitration.
This,
The OUR,
these two parties' relationship is just an example of the effect of the embargo placed by the minister.
That's right.
The embargo placed by the minister. If you now agree Rio 4, you're going to be capping contrary to my direction.
That's right.
So that's just an example of what
That's
was now forbidden.
and to add to my Lord's point, the minister himself considered that our Rio 4 ruling breaches direction. That's why we're here. Look at the minister's letter. He was totally offended and gave us a proper dressing down. That's why we're here. So the minister himself contemplated that, notwithstanding the provisions of the agreement between Cable and Wireless and Digicel, we were flouting his direction by adjusting the terms of the Rio between Cable
by
and
the ruling on Rio 4.
by the ruling on Rio 4, which impacted directly the agreement between Cable and Wireless and Digicel. That's why they are here.
And can you just give us the reference to the ruling which you say had that effect?
The Rio 4 ruling, my lord.
Or the relevant bit?
Rio 4 ruling, Rio 4, Rio 4. No, Rio 4.
Well, Rio 4 itself is at page
Yes, my lord,
581.
I'm looking for the Rio 4. I think.
581 is Rio 4.
That's good. It is at page 581 of the same bundle before your lordship, volume 2. Page 581, May 22nd, 2002. And it effectively begins at page 584.
Aren't we concerned with which is it, 2.4?
2.6 and 2.8.
2.6, 2.8.
But of course, it has a context, and the introduction says exactly what it is they are about.
If one has a look at 1.4 at page 584, we see how the whole
That's exactly
thing
where I was
works.
going to take you to. The office also regulates the retail rates that Cable and Wireless fix. The wireline portion of Cable Line is allowed to charge its customers for fixed mobile calls. These rates are a separate basket in CNWJ's price cap plan. The price cap is cost-oriented. The regulations that the office imposes on CNWJ through price cap and interconnection regulation also affect other mobile carriers. Additionally, the office, through its regulation of interconnection, limits the portion of FTM charges CBNW is allowed to retain. Retention is limited to a cost-oriented level. The remainder of FTM charges are distributed to the mobile carrier, whether CNWJ Mobile or some other mobile carrier. The preceding paragraph set out the history, paragraph 1, about the previous years, and bring you up to date as to where they are. And so that 1.5, 1.6 are the first set of ruling. Cable and Wireless is required to Cable and Wireless Mobile is required to participate in this FTM calling regime and may set any non-predatory price for mobile termination up to the cost or oriented maximum, etc. At page 588, my lord.
Could you read the end of 1.1? Well, it may insist if you're taken to the end of 1.1.
1.1.
The determination 1.1 on page 585.
Very well, I'll read the entire document, entire paragraph. Other mobile carriers may also set prices up to the same maximum rate, and Cable and Wireless fixes required to interconnect with all mobile carriers that choose to participate. Other mobile carriers may set a higher rate than the maximum allowed for Cable and Wireless Mobile, but CNWJ fixed cannot charge a higher retail rate to its customers than the maximum determined by the office, and shall not be required to pay any mobile carrier more than the maximum rate that applies to CNWJ Mobile. Thank you. So, while we are here, we may advert to Millard's example to understand this. The fixed network, which is Millard Phillips' landline, may charge a certain amount, but of the amount that Millard Phillips pays to his provider, they are not required to pay more than a certain amount above that to the mobile provider whom his daughters are busy accessing to speak to him when he calls them. So this effectively means that the mobile carrier who wants to charge for interconnection will either have to throw the extra amount on his own customer or reduce his interconnection charges.
And throwing it on your own customer is simply contrary to the principle of caller pays.
That's right. That's so, my lord.
Yeah.
Because the calling party who is paying. And that is why it doesn't matter so much to the person who is using the mobile instrument when he receives a call from the fixed line. He has no motivation to change providers. My friend, in answer to my lord's question, sort of say, well, there's competition because the mobile carriers may want to reduce prices between themselves. But let us assume that the persons using the mobile phone were not affiliated to my Lord Phillips. They would have no sympathy with the fact that he's bearing high charges. They have no motivation to change providers. Is he paying the bill?
They're concerned with what it costs them.
That's right. Whereas a fixed to mobile call, it costs them nothing where the calling party pays. Where there's only one fixed line provider, my Lord Phillips has no option. And the mobile provider, in the absence of regulation, can continue raising its interconnection charges until Lord Phillips says, you know what, I'm going to get myself a mobile phone and forget the fixed line. And that is where the anti-competitive problem, in answer to my Lord Brown, arises. Because my Lord Phillips has no choice. No real choice. The determination actually before the court is the one which puts on the cap. That's at page 592 of the same document, my Lord Clark. At the top of the page. That's the ruling, the reasoning towards the ruling begins at the previous page, 592. And if we begin at the top of it, page 591, just to look at the reasoning towards the decision, the costs for mobile termination are the most significant component of the overall maximum fixed mobile termination rates. As was previously noted, the office has determined that this charge shall be the sum of CNWJ's mobile termination costs plus an imputed charge for spectrum. And I don't know if my friend wishes me to read the rest, but they get into a lot of technical jargon there and thing. And then they come to the termination. 2.6 at page 592, the following maximum termination charges shall be applicable as of the 1st of July 2002, and they reduce the rates they had set in the earlier determination we had looked at.
So where were you reading from this?
I'm sorry, page 592, the top of the page, determination 2.6. It's in volume 2, man.
Yes, no.
Yes, sir.
That's what we're concerned about.
That's what we're concerned about. They reduce the rates for the first time, and we're all here before your lordships. The other one that is complaint, for which complaint is made, is 2.8, which is at page 594. And the reasoning for that is really at page 593, paragraphs 2.19 to 2.21, where they set out their reasons for, in effect, the purpose of this was to induce Cable and Wireless to negotiate the maximum settlement rate for international calls.
And it's 2.8, the international one, that has the effect of putting money that would otherwise have been going into Digicel's pocket into Cable and Wireless's pocket.
That is the appellant's way of looking at it, my lord. What the office says, and we can see it in 2.19 to 2.21, if I may just interpret. I almost use the word spin, but our interpretation of what they have done is this. International settlement rates were anticipated to be going down because what has been happening is that, in effect, the United States, their regulator, were concerned about the net outflow of foreign exchange. So we in Jamaica, to be frank, providers were using their international rates to subsidize domestic calls. Because we make more calls to America than America makes to us. We have a large expatriate population. So the provider was making the calls to overseas, the cost to connect overseas high. So they were using the profit from that to allow them to keep our prices down. The American regulator got sight of that and decided to regulate the amount that could be charged, that their regulator could be obliged to pay. That in effect. And if I'm going wrong, just correct me, right? Yeah, right. So they make more calls before it's correcting me. But the effect would have been that it was anticipated, and in fact it did happen. The international settlement rate would start to go down, and therefore the benefits, quote unquote, were going to be reduced. So this provision was designed to induce cable and wireless to negotiate higher settlement rates by saying to them, any amount over and above the cost of the call, you could put in your pocket. So it would be an incentive for them to negotiate higher settlement rates. It's a little more than that. But I crave your Okay. What it is, my lord? If the settlement rate were lower than the cost, then the loss would be for cable and wireless. They have to pay over to Digicel the first portion before they start to recover their own costs. But once they have covered that, then they would benefit. So it was an inducement to negotiate higher settlement rates with the international providers.
Now, Mr. Betts, I'm getting slightly concerned about time because how are we doing?
How are we doing? My lord, I believe, my lord, I can finish by past, because what I wanted to look at now was if there were any doubt about this interpretation of Section 6, that is, that it was intended to preserve the independence of the regulator, then this could be resolved by reference to the policy framework which was laid before Parliament by the Minister and which guided Parliament in its deliberations. This document emanated from the Minister. And the document is at page 1252 of Bundle 3.
125 bundle 1.
Pardon? I know that wasn't deliberate.
So which page again, please?
1244. It commences at 1244. I will say clear to the page that I want to look at. But 1244 Bundle 3, and it is an exhibit to the Minister's affidavit, and it is headed Telecommunications Policy, a framework. It predated the Act and was a policy document referred to at paragraph 7 of the Minister's affidavit, which states clearly that this was the concept that framed the, yes. In fact, the Minister's words in his affidavit was consistent with the terms of the policy framework. The government enacted the Telecommunications Act 2000. Paragraph 7. The document starts, of course, with the usual and a vision statement, and at page 1248 of the record, the document is paginated in fine print at the bottom. It's page 2 of the document. It says, Jamaica's telecommunications policy is to be based on the following. 1, an independent telecommunications regulator mandated to facilitate effective competition and regulate the telecommunications sector in a transparent, non-discriminatory, and accountable manner. At page 1251, the executive summary Telecommunications is to be regulated by an independent regulator, the OUR, operating in a transparent, accountable, and non-discriminatory manner. The regulator will be mandated to facilitate effective competition, except where ruled out by government commitments to honor existing licenses. At page 1252, my lord, paragraph 7 of the document, in light of the reform of the international accounting rate system and any imbalances identified between the structure of rates and costs, a rate rebalancing strategy will be developed by the regulator following consultation with interested parties. Now, this clearly is what 2.8 was intended to deal. At page 1255, the second paragraph, the government has designated the Office of Utilities Regulation to regulate the telecommunications industry, thereby to encourage investment and protect the consumer's interests. Of course, high prices is one thing the consumer is all about. At the bottom of the page, globally, an environment now exists in which competition in telecommunication services within a modern regulatory and policy framework has proven to be beneficial in many developing and developed countries around the world. Consumer welfare and economic development will be enhanced by the introduction of competition. Now, bear in mind that this time, there was only one, there was a monopoly. We were moving towards diversification of the market. And it continues throughout the document. Page 1257, rate rebalancing. Rate rebalancing is a change in the structure of telephone prices, but not the overall level, which is the subject of rate reviews. Economic efficiency is enhanced by a rate structure that appropriately reflects the underlying structure of costs. It is likely that at present the rates for domestic telephone services are subsidized by profits obtained by the incumbent PTC on international calls. The growth and expansion in the network, universal service obligations, and the development of competition will need to be examined against this background. And at the bottom of the page, a rebalancing strategy will be developed by the OUR after consultation with PTC consumers and other interested parties. As a necessary initial step, before the rebalancing rates can be implemented, the incumbent will be required to provide sufficient cost information to enable the extent of any rate imbalances to be identified. So there's no doubt, let me just finish, page 1261. It's very interesting, on the World Trade Organization. Jamaica has committed to all the regulatory disciplines in the reference paper.
Sorry, which page now?
I'm sorry, 1261, my lord.
1261, thank you.
Jamaica has committed to all the regulatory disciplines in the reference paper of the agreement. These commitments are as follows. And what is the first commitment? The creation of an independent regulator.
Well, which of these paragraphs heralds Section 6 of the Act?
Well, the document does not advert to the minister dictating to the regulator what to do.
Giving directions at all?
No, my lord, but it does say, refer to government policy. There are references to government policy.
So where's that?
I saw it at least once, my lord, and I'll find it.
I mean, this is, an interesting document, a year or two in advance of the legislation, and it tells us, as we've seen, what the broad policy underlying the legislation is. But I mean, we still have to give full effect to Section 6, don't we?
Yes, my lord. I'm sorry. At page 12, I'm sorry. I missed your lordship's question. Did your lordship ask me a question?
Sorry, I'm looking in this to see whether any light is going to be cast on the scope of Section 6, because we can't ignore Section 6, even if it isn't heralded in this policy.
My lord, I'm inviting the court to embrace Section 6. Section 6, remember, the Act gives the OUR control of certain things. It gives the OUR Act control of pricing, of resolving disputes, etc. But Section 6 allows the minister to influence the OUR's decisions in that regard. And that's what Section 6 does. So that, if we look, my lord, at page 1255, at the bottom of the page, globally, an environment now exists in which competition in telecommunication services within a modern regulatory and policy framework has proven to be beneficial in many developing and developed countries. So, you have a regulator. It is his duty to regulate, to consider disputes, to decide whether prices are cost reflective, etc. But in doing so, he should have regard to the government's policy. That policy cannot dictate the result of an inquiry, but it can guide the result. It can influence the result because it is communicated to him by a general direction. And this framework establishes that the intention of Parliament was to have an independent regulator who was not the foot servant of the minister, who would be told, lower prices, raise prices, don't touch prices at all under any circumstances. Yeah. And the submission, the reason for reference to this document, my lord, is this. If in construing Section 6, your lordships consider that there is any ambiguity about Parliament's intention that there should be an independent regulator who would itself consider these matters, then I urge your lordships to have regard to this policy framework, which throughout its contents emphasizes the independence of the regulator. You see, my lord, Jamaica is a poor and small country, but we want to attract big and wealthy companies to come and do business. They don't want to come to a banana republic where their prices are subject to the dictates of somebody who has nothing more on his mind than the next election or something else. Let us just be frank. So it is important that the Double Trade Organization Agreement is adverted to, and that they come in, they say, yes, there's going to be an independent regulator taking decisions on the prices I will charge based upon objective, scientific decisions. That is the purpose of this policy document. Not for a minister to come and say, look, under no circumstances, whatever the context, raise these prices or lower these prices. Or do it the other way. As of tomorrow, please, raise interconnection prices. Election will be 2 months down. Lower retail prices. It could never be the intention of Parliament. And the policy framework I submit, if there's any ambiguity in Section 6, makes this very clear. My lord, the document continues, and there are several other paragraphs. 1262, I just ask my lord to note it, I won't read it. 1264 at the bottom of the page, which interestingly refers expressly to terms and conditions of interconnection. And at 1265, and perhaps I should read this in fairness to my client. 1265 at paragraph 2. In carrying out its functions, the regulator should have regard to the following guiding principles. Paragraph 2. Fair terms and conditions. Technical standards and specifications should be reasonable and appropriate points of interconnection should be made available. Charges should be cost-oriented, and interconnection services should be sufficiently unbundled. I suppose that should have been unbridled. Unbundled? I'm sorry, man. It's a technical term. That the purchaser need not pay for components or facilities that it does not require. And it goes on and on, my lord. So, my lord, if there is an ambiguity in Section 6, we submit there is not, because it is the regulator who is to carry out its function. But if there is any ambiguity, I believe construction should lay in favor of an independent regulator and not against, given the policy framework. Now, my Lord, there was some criticism, my Lord, of the Court of Appeal by my learned friend by suggesting that they were unfair to the minister by suggesting that when he complimented, in fact, he remarked on the success of competition so far as part of the justification for his direction. And the suggestion was that the Court of Appeal had erred. But the Court of Appeal is quite correct, because the success of the industry to that point was due to regulation. It wasn't a free market untroubled by regulation. As we have just seen, the very agreement had been the subject of a determination notice which had fixed prices. So that criticism of the Court of Appeal, I submit, is not well founded. The Court of Appeal was quite correct to say that the minister was wrong and that in fact the success was due to regulation. The appellant at paragraph 16 of their case submit also.
Paragraph what?
16 of their case.
Yeah.
Submitted that section 3D of the Act allowed the minister sufficient flexibility to do what he did.
Missing words. Lord, could I just, I'm sorry, add in the missing words at that point?
Sorry, where?
Lord, it doesn't make sense. It's, however, section 3D is broadly drawn and allows the minister a significant degree of flexibility and discretion when, and then these words, deciding whether or not to issue policy directions under section 6. I do apologise, I forgot to correct that.
So you insert deciding whether or not to.
Yes.
Yeah. The point I make, my Lord, is that section 3 has the conjunctive and applicable to the various objects stated therein. In other words, the objects of the Act are not in the alternative. They are cumulative. And I submit, the minister is therefore not entitled to disregard entirely any of the objects, nor is he entitled to instruct the OUR so to do. There may be justification for saying, well, give one more weight than others at any particular time. But certainly, he could not possibly, which he purported to do, say, look, the dictates of an investor overseas coming in is to the only consideration to the exclusion of the concern for the consumer or efficiency or fair competition. And the recitals to his direction make no reference whatsoever to any other object but the attraction of an investor and what he calls competition simpliciter. I believe, my Lord, we have already looked at section 29, so I won't go over that. Safe to point out that the power to determine charges is not only in 29, it's in 30, 31, 32, and 33, each of which dealing with different scenarios and circumstances. And the direction applies whichever circumstance. So if somebody had been declared dominant the day after the direction occurred, we would be unable to ensure prices were cost reflective in accordance with section 33. And in this regard, paragraph 4 of the appellant's submission concedes that the minister's direction is silent as regards dominant carriers. And the silence makes it very clear that the direction applies whether or not a competitor was dominant. And therefore, if it were to be followed, it would have nullified section 33, where the statute stated prescriptively that the charges of a dominant player are to be cost reflective, and the OUR were to ensure that it was so, and even set out the formula that this cost reflective was to be computed by. So at the end of the day, my lord, if I may end on this aspect of the matter. The OUR, therefore, would be compelled, if this direction is upheld, to act not in accordance with its own professional opinion or judgment, but with the opinion of the minister. The OUR would therefore not, in any real or imagined sense, be exercising its function, the words of section 6 under the Act. Before I sit, my lord, and allow my friend Mr. Braham to deal with issue 2, I just wish to point to certain areas with which I depart from a learned friend, but which I didn't seek to interrupt him yesterday. And it has to do with matters like the definition of the word logical. Logical, my technical people tell me, my lord, does not relate to wireless contact or connection. Logical means a connection between two players that is not direct. So that if you have to go via another network, it's a logical connection, not a physical connection. They have their own language, my lord, I can't help them. Secondly, my lord, the spectrum was never controlled by Cable and Wireless. Prior to this act, it was controlled by the Post and Telegraph Department that had that responsibility. But as Cable and Wireless were the monopoly, well, they would have got all the... my lord, I wish also to indicate that the fourth provider was AT&T, but that the evidence emanating from our Director General, Mr. Hay, was that he had had a lot of contact with AT&T.
I don't think this goes to the principle at all.
No, my lord, but I just didn't wish it to remain untraversed, because my friend perhaps may have laid
Mr. Hay thought AT&T were going to come in anyway.
That's right, and they had email contact with him, which he exhibited. But, for the purpose of this, it's really, I agree, my lord, not. We have dealt with the question of the lack of prescription, my lord. We submit, my lord, contrary to my friend, that the powers under 29.3 and 29.4 are distinct. 29.3, and it's a neat distinction, but probably a necessary one. 29.3 allows the office to object to an agreement that has been filed. But 29.4, we submit, is a little broader. It says the office may make a determination of the terms and conditions of call termination, including charges, either on its own initiative in assessing an interconnection agreement, or in resolving a dispute. And to our mind, 29.3 contemplates an objection when the agreement is filed. 29.4 contemplates a determination if at any future time the office has cause to assess the agreement and finds that it is now running afoul of the objects of the Act. And of course, 29.4 has a further situation, and I think lends credence to my submission, where the parties at some point in the future, having entered into this agreement, have a dispute. When the agreement is lodged, it's unlikely they would have lodged an agreement about which they had a dispute. They would have been happy, here's an agreement. 5 years down the line, they maybe have a little dispute. And this is where 29.4 comes in. And they go to the OUR, then the office can determine charges, terms and conditions, including charges. Yes, and it is interesting to note, my lord, that section 32, subsection 2 of section 32 refers to the initial reference interconnection offer filed by the existing carrier. It is section 32.2, just below the letter B. And the existing telecommunications carrier shall submit its initial reference interconnection offer. That again suggests that there may be others. And it also makes it clear that it's not only the dominant provider who is regulated, but also the existing one, which of course in Jamaica was Cable and Wireless. We have looked, my lord, at the RIO, which was lodged and approved. My friend had made a lot of, much about the fact that the first RIO was approved, but we see where, at all times, further RIOs were contemplated. The office said so, and the agreement said so, and everybody knew. So I won't delve more into that. As regards the further directions in 2004 of the minister, which my learned friend quite happily brought to the court's attention, the submission we make, my lord, is that those two directions of 2004 demonstrate one solid fact, that by that time, the minister had properly advised himself as to what a general direction should be. I don't know if my Lord Brown is looking quizzical. Can you find it for me? My learned friend, there are contained in one of the newer bundles, my lord, which were filed yesterday by my learned friend. Looking for the title.
Yes, they were.
It says, Decisions of the Office of Utilities Regulation in 2004. Both post-date this matter and I submit have no real relevance, save as I say to demonstrate that the minister by 2004 had educated that direction, your lordship, may I remind you, stated, the OUR shall undertake and implement such acts of regulatory intervention in the mobile cellular market, however defined, as will stimulate sustainable, effective competition among carriers and service providers. Nothing wrong with that. And then he requests some information, which he's entitled to do. And then the following direction begins, with immediate effect, undertake and implement such acts of regulatory intervention in the market for international voice services as will establish an appropriate international settlement rate at which licensed operators shall provide such services while continuing to maintain sustainably effective competition among carriers and service providers. It is specifically intended that any ruling or directive to licensees issued by the regulator pursuant to this directive shall be immediately binding on such licensees pursuant to the terms and conditions of their license, and so on. So that he's guiding us and he's influencing us, but the ultimate decision of what those precise regulator steps are to be are ours. If we act unreasonably or ultra vires, thank you, my Lord. Thank you. So, my Lord, I would wish to end. Well, before I end, my Lord, my learned friend had also passed up. I'm sorry, there's just so much. A direction related to child services.
I don't think that's going to tilt the scales decisively.
I just remarked that whereas the minister has learned what a general direction looks like, my learned friend I submit has not. I end, my Lord, by referring to a letter at page 37 of volume 1.
Yeah, page 37. You find it?
Yes, it's a letter dated 26 April 2002, my Lord, from the attorneys for Digicel, complaining about the decision determination on Rio 4. And I asked my Lord to turn to page 40 of the record, page 4 of the letter, in which the attorney seeks to alienate the minister's section 6, minister's direction, which was purportedly issued pursuant to section 6. And the attorney says, "It was therefore with some disbelief that we received our client's advice that in the meeting under reference, your Mr. Hay indicated his view that the minister's direction was too specific and would not be complied with by your office. Frankly, this is an amazing revelation. We are constrained to attempt to point out politely that your office and executive director simply do not have the luxurious option of defying the minister, of whom you are the statutory servant." My lords, we urge you in your judgment to establish that the regulator is independent and that Parliament did not in any shape or form intend to make this independent regulator the minister's statutory servant. I will now allow my learned friend Mr. Braham to speak on issue 2, unless there can be a further assistance.
Thank you very much.
May it please my lords, I do hope to conclude within the time that is before lunch, because I think I can address this issue relatively shortly. Your lordship will see that my learned friend in his written case at paragraph 47 agrees that the direction, administrative direction or action is presumed to be good until invalidated by the court. Yes. That is to say that, but he goes on to admit that if the court should declare it to be invalid, then it has retrospective effect. And we have no difficulty with that position. And the issue 2, my lord, I had forgotten to point out is whether the minister's direction until pronounced invalid and/or ultra-virus by a court of competent jurisdiction was and remained a valid direction given under Section 6, and whether the OUR was bound to comply with such direction until the same was pronounced invalid by the court. So that the issue then was whether the OUR, having taken a position that the direction was invalid, was obliged to obey. And we say with respect, my lords, that the OUR was not obliged to obey a direction that they considered to be invalid, and we pray in aid, invalid and unlawful, a section of the judgment of the Lord Chancellor in Boddington's case.
You said they're not obliged to obey a direction that they considered to be unlawful. I think you mean a direction that was unlawful.
Unlawful,
yes.
Beg your pardon, sir. And Boddington's case, my lord, is in volume 1, tab 4, and for the purpose of time, my lord, I wish to take you to page 157 of the judgment, the last paragraph. It says, in my judgment, he's referring, my lord, to the decision of Boggs. In my judgment, Lord Ailes,
What page are we on, sorry?
page 157.
Thank you.
In my judgment, Lord Aylsham, in the passage of his speech relied upon by the Divisional Court in Boggs, was simply making the observation that in a flagrant case of invalidity, a private citizen might feel sure enough of his ground to proceed and rely on his rights to assert the defect in procedure, as Lord Aylsham described it, as a defense in proceedings brought against him. That, on the other hand, where a defect in procedure is trivial, that is, one which would not render the public body's act ultra-virus, the public body may feel safe to proceed without taking further steps to shore up the validity in law of what it had done by reconsideration of the matter, and that in cases in the grey area between these clear examples, it might be necessary for the private citizen to safeguard his position by taking the prudent course of seeking a declaration of his rights, or for the public body to reconsider the matter. But that would be for the citizen or the public body, as the case may be, to decide. Subject to any statutory qualification upon his right to do so, the citizen could, in my judgment, choose to accept the risk of uncertainty, take no action at all, and wait to be sued or prosecuted by the public body, and then put forward his arguments on validity and have them determined by the court hearing the case against him. That is a matter of right in a case of ultra-virus action by the public authority and would not be subject to the discretion of the court. I think that my learned friend probably agrees with this position as well, save to say that he's of the view that it ought not to be applied to a regulator, because he says it would lend itself to commercial uncertainty. And I say with respect that there is no warrant for any different treatment for any other person, statutory person, as in the case of the regulator, or just the normal subject at all. Indeed, my lord, the position of the regulator, if it follows an invalid direction, because that direction is treated, if the court should so find, as invalid from its inception, could open the regulator to liability for parties who may have been affected by the regulator's compliance with that invalid direction. So I'm saying that the obvious thing in this case is that the minister is entitled to take the matter to court if he doesn't agree with the regulator, get a declaration, get a stay if the regulator is intent on issuing a direction contrary to his direction, or, as in the case with Digicel, Digicel is entitled to go to court to seek the court's intervention. So I say with respect, my lord, that when you look at the principle should be applicable to all parties.
Is there any authority that suggests that there's ever been a liability established by somebody for obeying some apparent imperative, whether it's a bylaw or a direction or something like this, for obeying it rather than for disregarding it?
I was not able to locate any, sir. So that is the position subject to our written case, my lord, what we would wish to say in relation to this issue. In relation to the fifth issue, which is the raising of the Interpretation Act, Section 29, that is to say that the ministerial position, direction, ought to have been gazetted. I just say shortly, my lord, that in our written case, paragraphs 124 to 131 that we rely on same, and just to point out to you, my lord, that in the Interpretation Act,
Sorry, your printed case 124.
paragraphs,
I run out at, don't I? I thought I ran out at 90.
yes, but I'm referring to the paragraphs, my lord.
I'm looking at paragraph 2.
I beg it.
Aren't you the second? You're the second report.
Your English stopped at around 90. Remember?
Page 65 of the written case, my lord. Page 65.
Paragraph 120.
Paragraph 124.
Oh, sorry.
It's indexed.
Right.
The relevant section. My lord, have you page 65 of the written case?
Yep.
Yes. Just wish to briefly take you to section 31. It says that all regulations made under any act or any lawful authority and having legislative effect shall be published in the Gazette, and unless it be otherwise provided, shall take effect and come into operation as law on the date of such publication. So that it is important, my lord, to note that if this section applies, that it is the intention of Parliament that failure to comply with it has an effect. If you do not gazette the provision, it does not take effect. And so that I think that when your lordship come to interpret it, your lordship, I ask with respect to bear in mind that when it appears that the intention of Parliament is to treat a deviation from this provision to be substantial, so that it goes on to say, if you don't comply, then the provision that you issue does not take effect. Now, your lordship will note from the record that the minister had given instructions that his direction was to be secret, private, confidential, which I find to be most unusual. Having regard to that he's exercising a statutory power, it must be imperative that the public and the players in the market be aware of it. It ought not to be a matter that rests in the bosom of the minister and the OUR. Indeed, your lordship will note that even though the minister was complaining that it ought to be confidential, the appellant was aware of it. We don't know how they got to be, but they were aware of it. But the point is, if your lordship should accept the appellant's case, that the minister was entitled to give the direction in the way that he did, it means that the minister basically would have the power to affect the provisions of the legislation in relation to the carrying out of the duties and functions of the OUR. If he has that power, then that ought not to be secret. That is a matter that the public at large ought to know.
Are you saying that that power would in effect be amending the provision or something? Is that why you say it has legislative effect?
It has, well, certainly, my lord, I would use the word amend, but what it does, it prevents it from taking effect, prevented the OUR.
It's got to have legislative effect before this
I agree.
provision applies. So the question is, how do you say it has legislative effect?
It has legislative effect, my lord, because it appears to me, with respect, to affect a wide community in terms of how that community is affected by the law, the Telecommunications Act, how they are to treat with it, how it is that it affects them, particularly the parties in the market, and it certainly affects the determinations by OUR when it comes to consider matters, so that it deals with how the legislation is to be applied and how the OUR is to carry out its function. And to my mind, that, with respect, is legislative in nature. Subject to your lordship.
This doesn't seem to be a point that occurred to the office earlier on.
Well, indeed, my lord, it seems to come with hindsight.
Reflection, decided not to proceed.
7 years later.
Still, I suppose if it's a good point, that may not matter.
Yes, but my lord, it's though late, it is apparently a good point, and we urge you to consider it favorably.
I think our reaction would likely to be that if we thought it was a good point, we wouldn't allow you to take it.
Subject to your lordship, those will be my submissions.
Thank you. Ms. Minot-Phillips, I expect you would like the lectern to be passed to you, would you?
Well, until it gets here, I can proceed in the
That's very gallant.
Well, as it falls to me to address any remaining matters on the issues 1 and 2, not already addressed, in our case, to the extent that there are any that also have not been. Thank you. I'm obliged to my friend. Sorry about that.
I agree with you.
My learned friend, Mr. Garcia, will be, should you allow, will address you on the Interpretation Act point and in relation to agreed issue number 3. Now, there are only 2 small points that I wished to raise, my lads, in relation to the appellant's arguments on issues 1 and 2. And, my lads, the first one is on the issue of whether the ministerial direction issued under Section 6 was of a general nature as to the policy to be followed by the OUR in the performance of its functions. And on that issue, whether in fact the Court of Appeal was correct in its findings at page 2177 of volume 5, that the direction was not of a general nature. And if you look, my lads, at, it's in volume 5, page 2177. There's a very succinct statement of the Court of Appeal that speaks about the minister's direction. And it says, at about line 13, the minister pinpointed specific areas of the regulatory functions of the OUR, namely A, its powers to determine rates or fares to be charged for a telecommunications service under Section 4.4 of the OUR Act, its power to provide for the imposition, monitoring, and enforcement of price caps, Section 46.2 of the Telecommunications Act, its powers to assess the terms and conditions of call termination, including charges, in interconnection, whenever it becomes necessary, and your lordships would have picked up the typographical error there, section 29 of the Act, and D, in respect of a dominant public voice carrier, if and when so declared by the OUR, its powers to assess on interconnection the terms and conditions, including charges, section 30, and the prices, costs, and charges, section 33 of the OUR Act, and it directed the OUR not to perform such specific functions in respect of any mobile competitor. Now, my lords, if you look at paragraph 22 of my friend's written submissions, that is the appellants. It is there set out, my lords, at pages, he identifies a section of the judgment that I have just read, or part of which I have just read, and goes on to state, the President, as President of the Court of Appeal, identified the following areas in which the Minister had directed the OUR to perform its regulatory functions in the context of and subject to the direction. And then he lists the same 4 items as the learned President of the Court of Appeal listed. However, in fairness to the learned President, I think the learned President was actually saying which the Minister had directed the OUR not to perform its regulatory functions. And there probably should be a full stop there in fairness to the President. As regards subparagraph A of the reasons set out by the Court of Appeal for its finding, the appellant's argument is that the OUR did not have a power to determine rates or fares to be charged for a telecommunications service under Section 4.4 because the Telecommunications Act specifies the manner in which a licensee may fix the rates it charges its customers for its services. And the reference then was to Section 11, subsection 3 of the OUR Act. I think the submission was basically to the effect that, or the effect of the submission was that the ministerial direction couldn't affect a power which the OUR never had. But it is our submission, my lords, that the Telecommunications Act, and applying the wording of Section 11.3 of the OUR Act, does not specify the manner in which rates may be fixed by a licensee for the services it provides to its customers, although it does address elements which go into the making of that charge. Example, interconnection charges and price caps. Subsection 4 of Section 4 of the OUR Act, interestingly, my lords, which is the specific provision of the OUR Act that states the office shall have power to determine, in accordance with the provisions of this Act, the rates or fares which may be charged in respect of the provisions of a prescribed utility service, defined in the Act to include telecommunications. That subsection, my lords, of that Act was not reproduced in the Telecommunications Act, as was the case with, for instance, subsection 1 of subsection 4 under the OUR Act, which was in large measure reproduced in the Telecommunications Act. The result is, in our submission, the determination of rates to be charged by utilities to their customers remains to be exercised by the OUR under the OUR Act and is not superseded by the powers under the Telecommunications Act.
Is the Telecommunications Act number 14 of 2000?
The Telecommunications Act is not, my lords, it is number 1.
Lord, this is the one we've been trying to get for your Lordship, and we think it's on its way. But it's on its way in Jamaica time, at 9:30 Jamaica time, which is coming up soon. So I hope to have a copy for your Lordship.
Thank you.
Well, let's...
Because under section 4, against section 4, it says functions of the office, 14/2000. And that, well, I suppose we'll see when we get it, but subsection 4, does that appear in the 2000 Act or only in the, whatever the old Act was, 1995 Act? Section 4, subsection 4.
Subsection 4, subsection 4 appears in the 95 Act. That is the OUR Act,
Yes.
my lords.
But not in the 2000.
It does not appear in the Act number 1 of 2000, the Telecommunications Act.
What about in, well, we'll see whether it's in Act of 14 of 2000, you don't know.
I am unable to answer that, my lords. My lords, so a restriction on the OUR's power, and your lordships will recall that term is helpfully embraced under the definition function under the Telecommunications Act. A restriction on the OUR's power to determine charges for call termination in the realm of interconnectivity would therefore impact adversely on the OUR's power to determine rates charged to the public under Section 4.4. The submission is therefore that the Court of Appeal was correct in so finding in Part A of its finding on page 2177 that I took you to at the start of my submission. Well, I think the other elements of the finding of the Court of Appeal have been addressed in our written case and in the written and oral submissions to some extent of my learned friends, for counsel for the OUR, and I won't repeat them. I just wish to say, my lords, that in relation to, I think it is a question that your Lordship's board raised about whether there was in fact a mandatory element to Section 6 of the Telecommunications Act. My view differs somewhat from my friend Mr. Batts. I believe that there is a mandatory element to Section 6, but so far as the direction that is given is lawful, because the Act does not contemplate that a direction would be unlawful. So to the extent that the direction is in fact lawful, then there would be certainly, I think, a duty to give effect to those directions. There is only just one other small point, my lords, which I don't know if you would like to take it after the break or whether you wish me. It will take no more than, I think, 2 minutes, unless your lordship.
On page 2177, when it says the Minister pinpointed specific areas and lists them, where did he do that?
Minister what?
The Minister pinpointed specific areas. That's 2177 of the Court of Appeal's judgment.
The bit you showed us at the beginning.
Well, if you look at the ministerial direction, my lord, which you will see at page of the same Court of Appeal judgment, you will see it at page 2159. Yes, my lord. In item 1, it says the OUR is not to intervene in the mobile cellular market by setting rates, tariffs, or price caps on the interconnection or retail charges made by any mobile competitor. So what the President is here doing on 2177 is showing how that direction affects its power to determine rates and fares under 4.4, its power to impose, monitor, and enforce price caps under 46.2, its power to assess terms and conditions.
It's the words, what he's saying is, when one looks at that direction, where one finds rates and tariffs, then you look to the section.
You do, yes, and so, yes, that is what. Yes, my lord. So, is this a convenient time?
Yes, we'll adjourn now and take your last point too.
Very well.